get started with the live stream. Looks like we are now streaming live. Can everyone hear me okay before I proceed?
Yes.
Okay, great. So welcome to our hearing. We are holding this hearing electronically with the agreement of all of the parties. Before we go on the record, this is the appeal of Casiano Lancaster Investments, LLC. It's OTA case number 2208-11240. Today is Tuesday, August 13th, 2024, and the time is 1:02 p.m. Again, as I mentioned before we go on the record, I want to say that this is Judge Clutter. With me are John Johnson and Seth Elsom. And as indicated in the revised notice of panel dated July 30th, 2024, hearing officer Elsom will replace Tommy Lung on the panel. I wanted to ask the parties, are there any objections to the substitution of Tommy Lung with hearing officer Elsom today?
No.
This is Chris Cook. No, Judge Clutter, we do have two preliminary items we'd like to discuss. I don't know if you want to do that when we're live on the record or beforehand.
Yeah, we can discuss them. They may overlap actually with the preliminary items that I have. So I'll ask if there are any additional items before we go on the record. But I just have a couple other things to cover first. If you can hold off, maybe it might overlap. So just a couple general rules. I am the lead administrative law judge in conducting this hearing. However, all three panel members are co-equal decision makers. And also present with us is our stenographer, Miss Alonso, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everybody speaks one at a time and does not speak over each other. Please speak clearly and loudly. As needed, Ms. Alonso will stop the hearing process and ask for clarification. And after the hearing, she will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The hearing transcript and the video recording are part of the public record. This proceeding is a live broadcast, and any information shared on your screen is publicly viewable. The Office of Tax Appeals is not a court. We are an independent appeals body, and the Office of Tax Appeals is staffed by tax experts and is independent of the state's tax agencies. If there are any questions during the process or any issues regarding technology, please direct them to me. Now, the two preliminary items that I had,
Just want to make sure you can hear me.
I can hear you.
Great. Thank you.
So the preliminary items that I have are just two. There was a pre-hearing conference that we held on July 18th, 2024. At that pre-hearing conference, the issues were discussed, and one of the issues in the pre-hearing conference minutes and orders was whether appellant was subject to the LLC annual tax and fee. Mr. Schwartz, do you still contest the imposition of the annual tax and fee, or are you only contesting the penalties and interest today?
Just the penalties and interest.
Okay, great. Thank you. I just wasn't sure. And then the other item, preliminary item, is that following the pre-hearing conference on August 9th, 2024, appellant submitted two new exhibits. One was, I believe, a letter from the CPA and also the LLC operating agreement. I wanted to ask Franchise Tax Board, do you have any objection to those new exhibits?
Franchise Tax Board has no objections to those exhibits.
Okay, and then I just wanted to check with the parties. Are there any other new exhibits for consideration today?
No.
Okay.
No new exhibits.
And now, before we go on the record, Franchise Tax Board, did that cover your preliminary items, or did you have additional?
Thank you, Judge Clutter. There's two additional items. One is the $76 of the monthly portion of the late payment penalty assessed on tax year 2017. FTB was looking at that, and that should be removed, and we'll allow a refund of that amount. And then the second issue is the pre-hearing conference minutes and orders. Issue number 5, the legal standard was listed as reasonable cause for the under the estimated LLC fee payment penalty, but under section 17942, actually, there's no reasonable cause exception in there. So we think that the issue statement may be misleading.
Yeah, I'm looking at that. So I guess it was framed as whether appellant has established any basis under the law to abate the penalty. So I'll make sure to update that it's noted essentially.
Thank you, Judge Clare.
So let's go ahead and go on the record now that we've covered those preliminary matters. I'd like for the parties to please each identify themselves for the record, beginning with appellant.
This is Michael Schwartz, and I apologize that my video doesn't connect. We did try to troubleshoot after the preliminary hearing. It just doesn't work in Zoom, so I'm just here on the audio.
Thank you. And for respondent, Franchise Tax Board.
This is Chris Cook, attorney with the Franchise Tax Board.
My name is Topher Tuttle, also an attorney with Franchise Tax Board.
Thank you. And the issues that we have for today, there's 6 of them, I believe. Issues 2 through 5. I'm sorry, issues 1 through 4 are whether appellant has established reasonable cause to abate late filing penalties, the demand penalties, the late payment penalties, and then that last one is whether appellant has established any basis to abate the late payment of the estimated LLC fee. And the other 2 issues are whether FTB properly imposed the filing enforcement cost recovery fees and whether appellant is entitled to interest abatement. With respect to the evidentiary record, FTB provided exhibits A through T. Appellant did not object to those exhibits, therefore those exhibits are entered into the record. And appellant provided exhibit 1 through 3. FTB did not object to the admissibility of these exhibits, and therefore those exhibits are entered into the record. As a reminder for our time today, we have 10 minutes for appellant's presentation, 10 minutes for Franchise Tax Board's presentation, and then 5 minutes for appellant. You can have a closing statement and rebuttal as you wish. So, Mr. Schwartz, before you before you begin, I would like to swear you in for your testimony.
Sure.
So, I ask, do you swear or affirm that any testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
So now that I have you sworn in, I ask that you can begin your presentation as you like, and you'll have 10 minutes.
Okay, sure. So I appreciate everything and the discussions up to now. I think that everyone was involved up till today understands and agrees that I paid the full amount, the taxes, the penalties, and interest as soon as I found out about it, which was January 2022. I think we also all know that I'm not some criminal trying to game the system and avoid paying my taxes. I presented evidence from my CPA. Basically, she just screwed up. She filed 2015 or 13, 14, and 15, and then forgot to file the subsequent years until you guys notified us. And then we filed 2016 through 2019 immediately and paid everything. At that time, I filed about 15 tax returns a year, and I just sign what she sends me. I don't, keep track of I wasn't where I situation where I said, hey, why do we not have a 2016 California return for Casiano Lancaster? So, and so my question is, I have a couple questions, or I guess arguments. I don't understand why Franchise Tax Board comes to me at the end of 2021 with a bill going back from 2016. That's like 6 years after the fact. To me, it seems unreasonable that Franchise Tax Board did not notify me of a late fee of unpaid taxes in a timely manner. It's just, to use a crazy example, I mean, what if they sent me a letter today about something in tax year 1999, come 25 years after the fact, and say, well, it was $100 that you owed from 1999, but with interest and penalties now you have to pay 25,000. I mean, that's kind of how I'm feeling. I don't know how much interest and penalties accrued between 2016 and the end of 2021 when I was notified of the problem. And I know it's all my responsibility and everything, but it just seems to me, unreasonable or unfair that you guys have come to me 6 years after the fact and say, well, you owe us from 6 years ago, and now there's interest and penalties on that. Let's see. So in my mind, that's just not right. And but I paid it all. I paid it in full the day that I knew about it, and I asked questions later, filed an appeal. I feel that the Franchise Tax Board's delay in notifying me of, unpaid taxes from 6 years ago is unfairly increased my financial burden. Lastly, the LLC, I talked to Chris like a week ago, and that's why I sent my operating agreement. Casiano Lancaster LLC was a single member LLC. There were not 4 members. I guess that's another area that my CPA screwed up. And in the letter that she provided most recently, she says it's a single member. So if that can, save me a little bit, I really like to not have to pay any of the interest and penalties, but I'm throwing that out there. And in conclusion, I feel I should not have to pay any interest or penalties. Had the FTB notified me in 2017 about, back taxes from 2016, and I neglected to pay, that would have been a different story. I just feel like I've done nothing wrong, and now I had to pay 10,900 change between interest and penalties. I thank you for your guys' time.
This is Judge Clutter. Thank you, Mr. Schwartz, for your presentation. I'd like to turn it over to Franchise Tax Board. Mr. Cook, are you ready to begin your presentation?
I am.
Please begin.
Thank you. Appellant Casiano Lancaster Investments LLC was organized in California in 2012. FTB's records show that appellant timely filed its tax returns each year from 2013 through 2015. But beginning with its 2016 tax year, it failed to timely file its returns or timely pay its taxes. That is why at issue in this case are the penalties and related costs and interests that the law required FTB to assess for appellant's failure to timely file and pay for taxes and pay for tax years 2016, 2017, 2018, and 2019. Particularly at issue is whether appellant has demonstrated reasonable cause to abate the penalties for delinquent filing of the tax returns, the per member late filing penalties, the demand penalties, late payment penalties, or whether the law permits abatement of the penalties for the late payment of the estimated LLC fees, cost recovery fees, or interest. First, to address the penalties caused by the appellant's filing its returns late. The demand penalty was assessed for 2016 and 2018 because FTB had sent appellant demands for tax returns that went unanswered by the response deadlines on these notices. Delinquent filing penalties were also assessed because, as summarized in respondent's opening brief at page 5, the tax return for each year at issue was filed late. And the additional per member late filing penalty was also assessed because appellant self-reported on each one of its returns having 4 members. There was no dispute that appellant did not timely respond to FTB's demand notices, nor any dispute that it did not timely file its returns. So the only legal pathway for these penalties to be abated is if appellant can demonstrate with evidence that there was reasonable cause for the delays. Appellant needs to provide evidence showing that it made efforts to timely file its returns or respond to FTB's demand notices, but was otherwise prevented from doing so. The standard of reasonable cause is evidence that appellant exercised ordinary care and prudence, and evidence that cause existed that would prompt an ordinarily intelligent and prudent business person to have acted as appellant did under similar circumstances. But appellant has only argued that the returns were not filed on time because appellant relied on its tax preparer to file the California returns. But there is a long-standing legal precedent that a taxpayer's reliance on a tax preparer or agent to timely file or pay taxes is not reasonable cause. Exercising ordinary business care and prudence required appellant to do more than just delegate the tasks to file a return, because under the U.S. Supreme Court precedent adopted by this board, appellant's duty to file cannot be delegated. And if appellant itself was unaware that it had a filing requirement, that is simply an admission of the lack of ordinary business care and prudence concerning its tax obligations. So while appellant has not established reasonable cause, appellant has not established reasonable cause, and FTB asks OTA to sustain the assessment for the demand, delinquent filing, and per member late filing penalties. As for the penalties related to appellant paying its taxes late, there is no argument that appellant paid its $800 LLC tax and LLC fee late for each year at issue. Like the filing penalties in this case, late payment penalties may be abated with a showing of reasonable cause. And since, again, appellant has not demonstrated reasonable cause, only asserting that it did not know it had to pay taxes and its reliance on its return preparer, FTB asks OTA to sustain the assessment of the late payment penalties. Relatedly, the penalty for the underpayment of the estimated LLC fee was also assessed on tax years 2016, 17, and 18. The law requires an estimate of the LLC fee to be paid during the LLC's tax year. There is no reasonable cause exception to the imposition of this estimated fee penalty, and there is no question that appellant did not timely pay the estimated LLC fees. So FTB asks OTA to sustain assessment of the estimated LLC fee penalty. Further, cost recovery fees were assessed on tax years 2016 and 2018 because appellant did not timely respond to FTB's demand notice. There was no law allowing abatement for the cost recovery fees, and since appellant has not demonstrated reasonable cause to abate the related demand penalties, FTB asks OTA to sustain assessment of the cost recovery fees. Finally, the law provides that interest may be abated in limited circumstances described in the Revenue Taxation Code, depending on whether FTB committed an unreasonable error or delay, whether appellant was unable to pay interest due to extreme financial hardship, or the charge of interest was caused by reasonable reliance on FTB's written advice. Appellant raises for the first time in this hearing that the argument that FTB committed an unreasonable error or delay in this case and notified appellant too late about its filing requirements and its taxes. However, there's no argument, and briefing may be done if requested, that FTB did not follow the law and issue its notices within the statute of limitations required, or that any other delays were caused unreasonably, that contravene the law. Since appellant has made no contention or any other evidence that any one of these other circumstances to abate interest applies in this case, FTB asks OTA to sustain that interest was assessed and paid properly. To summarize, there is no legal basis exempting appellant from its tax obligations for the years at issue, no showing a reasonable cause, nor any other basis to abate penalties, the related costs, and interests. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Cook, for your presentation. I did have just one question for you. When we were off the record, you mentioned that with respect to the 2017 tax year, there was a refunded amount. So I was wondering if you could please state that on the record and clarify which late payment, like which statutory penalty the abatement is for.
Yes, it's for the 2017 tax year, and FTB has determined that $76 of the monthly portion of the late payment penalty should be removed from the assessment and refunded to appellant.
Thank you, Mr. Cook. I'm just going to turn to my panel and ask them if they have any questions for the parties. Um, Judge Johnson, do you have any questions for either of the parties?
This is Judge Johnson. Just one question going back to the $76. That's the penalty imposed under 19132, is that right? Just several penalty issued. I'll make sure we get the right one.
Yes, it's under the late payment penalty 19132.
Okay, that's all. Thank you.
Thank you for that clarification. Hearing Officer Elsom, do you have any questions for either of the parties?
This is Hearing Officer Seth Elson. I don't have any questions at this time.
Okay, so we're allotting here 5 minutes for appellant. You'll be able to provide a closing statement and a rebuttal. We had just asked that before you speak, you may need to press *6 to unmute yourself. I'm wondering if you could try that to see if that works for you.
Okay.
We can hear you. So if you would like to make a final statement or any rebuttal to what FTB has presented here or anything else you've prepared before the case is submitted.
Just that Chris has done some good research, but I'm just, my whole point is that I paid in full the minute that I became aware of this. And I just think that it's not fair that I would have to pay $10,900 in interest and penalties. Any relief I can get is appreciated. Thank you.
Thank you so much, Mr. Schwartz. And I just want to ask my panel members one more time. Judge Johnson, do you have any other questions?
This is Judge Johnson. No questions. Thank you.
And Hearing Officer Elsom, do you have any questions?
This is Hearing Officer Elson. Mr. Schwartz, I did have just a couple questions to understand the kind of the historical context behind your operation of this entity.
Sure.
I did notice that your preparer has a Florida address, and is this a preparer that's based in Florida? And if so, does she have knowledge of California filing requirements, or did she provide any written statement or, any legal basis for filing or paying fees, anything of that nature?
She's been the family CPA for many years prior to me even moving to California. And, she told me that she knew everything. And we haven't had any other problems. I've been living here and operating many entities since 1995. So she seems to be doing a pretty good job, except for this one.
And then I wanted to clarify just a couple statements in your reasonable cause statement to FTB. You stated that the LLC had not made money and had losses for each year. And I wanted to clarify, were those losses for the years at issue, or was that since the inception of the entity?
Every year since from when it started 2012 till it closed in early 2020.
Okay. The last question, I just want to understand the filing. For 2015, it looks like you timely filed on an extension on September 15th, 2016. And then you made timely payments of the LLC fee of $2,500 and the LLC tax of $800 on 4/15 of 2015. So I just kind of like to understand what the difference was between that year and the subsequent years. I know your CPA had mentioned that she believed that there was no federal filing requirement, and so the files for the California side may have gotten deleted. Could you just kind of clarify some of those items or speak on that?
That's exactly it. She just either lost the file or they, took it out of the filing system, and she forgot and I forgot, and that's where we're at.
Okay. Thank you, Mr. Schwartz.
Thank you.
So Judge Clutter, Hearing Officer Elsom, I'm assuming you have no more questions.
That's correct. No more questions.
Okay, so then that concludes this hearing. The panel members will meet and decide this case based on the documents and the testimony that was presented today. We'll issue our written decision no later than 100 days from today. The case is submitted and the record is now closed. And I believe that this concludes this hearing session.